The objection was sustained. Go ahead.
I didn't hear you, Your Honor.
The objection was sustained. Go ahead.
Your Honor, I just have a few more points to make, and I will sit down. On the issue of undue consumption of time, I'd like to give the court an example of what I'm talking about. One of the plaintiffs in that civil case against Mr. Jackson where the plaintiffs lost and were awarded, Mr. Jackson was awarded over $1 million in legal fees and costs. But someone named Adrienne McManus, her deposition, I am informed, was taken 8 times in that case. That's just one witness. And apparently in her trial transcripts, which we have, she is changing her testimony so often that she gets back and forth. The testimony is prolonged, and the point I'm making is that's just one witness. 8 depositions plus 6 months of trial testimony. In the Geordie Chandler civil case, you had approximately 5 months of litigation before the case settled. You had numerous depositions and numerous pleadings in civil discovery that would be relevant and usable. Now, I want to emphasize something we said in our papers. The testimony that the prosecutor wants to introduce concerns 7 alleged victims with only 1 scheduled to testify. This testimony has been presented to 2 criminal grand juries in Los Angeles and Santa Barbara, neither of which ever returned an indictment, and it's been rejected by 1 civil jury in the longest civil trial in the history of this courthouse. Now, I know the prosecutor likes to say, well, those grand juries were purely investigative only. But obviously the purpose, from Mr. Sneddon's point of view, to the degree he controlled anything, was to see if they could bring criminal charges. And neither grand jury brought a criminal charge. And many of the witnesses who, not many, some of the witnesses who sued Mr. Jackson in the civil case also testified in these grand juries where no criminal charges were ever brought. Now, there is evidence, there is case law to the effect that if one is acquitted of a prior sexual offense, the evidence of the acquittal is admissible. I haven't seen anything about whether or not you can bring in the fact that a grand jury refused to indict, but certainly the fact that they went to 2 grand juries, there was no indictment, they went to a civil jury, they lost, and the fact that they don't have alleged victims with the exception of 1. Plus you're talking about lengthy civil litigation, numerous depositions, numerous pleadings, numerous witnesses, plus the fact that the defendant has a right to defense as if it were a separately charged crime, and that means every type of defense imaginable, including rebutting the character nature of the evidence, which would mean opinion evidence, reputation evidence, and maybe specific instances of conduct, will unduly prolong the trial. Finally, Your Honor, I will get back to where I started. Evidence Code Section 352 is sacrosanct in this courtroom. It is a fundamental component of the statute of 1108. It gives this court enormous discretion to eliminate potential for prejudice, for bias, for a prolongation of the trial that would be unproductive and not in the public interest. It allows this court enormous discretion to make sure issues aren't confused. It enables this court enormous discretion to make sure that the burden of proof is not fundamentally changed, that the presumption of innocence remains intact, and that Mr. Jackson has a fair trial. For the reasons I've articulated, we're asking that the prosecution's motion be denied in its entirety. Thank you.
Counsel, rebuttal?
Your Honor, I think that what we've heard here this morning is something akin to a pattern that we've seen in this case, and that is reckless, exaggerated and misleading statements on the part of counsel with regard to what he believes the evidence and the testimony has produced so far in this case, and similar to ones he's made in opening statement, and I say this for this reason. I'm not going to get into a contest of saying what we believe the evidence has shown or what the credibility of the witnesses are to this court, because this court's been here and you've seen it for yourself. But I am going to point out that since Mr. Mesereau stood up in his opening statement and made certain assertions to the jury in this case, we've blown massive holes in his theory of this case. The witnesses that he said was, Janet was going to do that and Janet was going to do that. The fact of the matter is they're now shifting gears from the original hypothesis to say, well, she wasn't directly involved, like I said in my opening statement, but now she's indirectly involved. Because we've proved otherwise. Similarly with the fingerprint evidence, the fingerprints were on there because the kids touched it at the grand jury. Now we have the evidence from the people to show that those fingerprints were on magazines that weren't even in the grand jury, so they couldn't have been put on in the grand jury. Those magazines were at the Department of Justice being examined for trace evidence at the very time that the defense alleged somebody put their fingerprints on them. It's this kind of stuff that bothers me about Mr. Mesereau's statements to the court. But rather than get in a point-by-point recitation, I'm going to rely, as I have before, and we will to the end of this case, that the court can make up its own mind about what the court feels that the evidence has produced in this case. I will only say this, and this will be the only thing I will say. Gavin Arvizo sat on that witness stand for almost 3 days. The first day he was on there for almost 40 minutes, and Mr. Mesereau was as abusive, was as mean-spirited, and was as obnoxious, frankly, as you could be to a child witness in a case. He spent the next 2.5 days with binder after binder after binder coming up here and asking things. That kid didn't have a piece of paper in front of him. Not a single piece of paper. And I think it was a remarkable job that child did. He was never once tripped up about the fundamental fact that the defendant in this case molested him. We produced evidence that have blown holes in the defendant's case, from Palanker to Coleman, and we'll have some this afternoon when the Lopezes testify. That the defense has consistently exaggerated, and misled the jury in this case, and the court. With regard to the second part about the civil case, I think, again, this is a case where many of the things Mr. Mesereau said are completely misleading. The first thing to understand is that the issue in that case had nothing, zero, zilch, nada, nothing to do with child molestation charges. That evidence was specifically excluded by the court. The depositions that make reference to that information contain pages of probably less than 100 pages in that deposition devoted to that part of it. The deposition mostly, and the trial, was entirely devoted to issues of harassment, intimidation, of illegal surveillance and monitoring of conversations. It had nothing to do with the facts of this case, as we're attempting to put before the jury the uncharged offenses. Nothing. It lasted 6 months because the defendant in that case persistently did not show up for long periods of time. And unlike this court, which took a very firm rein on the defendant's inability to show up on time, that court did not. And that's why that case lasted 6 months. I think it's also important for this court to know that the information that we're putting before this court from the witnesses that are going to testify is information that was produced before that case was filed. And in fact, part of the intimidation and the harassment allegations involved in that lawsuit were the product of what happened when these people cooperated with the Santa Barbara District Attorney's Office and the Santa Barbara Grand Jury. But the fact of the matter is that the statements that were made prior to the time of the lawsuit, and were made at or about the time of the investigation, and to law enforcement officers. I think once and for all, I would like to, because I was the one involved in it, to put to rest the thing that Mr. Mesereau keeps saying over and over and over again, as if he says it enough times that somehow it's going to become the truth. It isn't the truth. It isn't factually correct. And it's simply false. The grand juries, there weren't 2 separate grand juries. They were a grand jury impaneled to hear some witnesses, for the convenience of those witnesses, in Los Angeles, and there were some witnesses that were heard in Santa Barbara County. None of those witnesses, nor were there any indications to either one of those grand juries that an indictment was being sought. And never was there any request for an indictment, or any charges, or any information in any smallest scintilla of a way presented to those grand juries. The fact of the matter is, the grand juries never considered it simply because at that point in time, Jordan Chandler decided that he was not going to cooperate any further with the law enforcement agencies. And at that point, the grand jury, with regard to most of those witnesses, was completely shut down. Which brings me to another one of counsel's points, that somehow we can't prove a case because we don't have a victim. Well, then I guess we would never be able to prove a murder case then, would we? Because we sure as heck can't put the victim on the stand. And yet on the one hand, the defense attorney tells me that one of the reasons we have a real problem here is because we have Gavin Arvizo on the stand and we have no corroboration and we have no eyewitnesses. Yet when we have an eyewitness, it's no good anymore and we can't call them. Well, you can't have it both ways. You simply can't have it both ways. And you simply can't ignore the fact that the very things that the defense attorney's talking about in this case, there's no DNA and there's no eyewitnesses, are the very reasons that the legislature says specifically that 1108 evidence is admissible. And what would you expect, 9 months later? Of course, they never bother to say that. Oh, there's no DNA. 9 months later? There's no underpants found 9 months later? The very underpants that the child left there because the defendant asked him to leave them there. Would you reasonably believe that 9 months later that stuff would be there? That they didn't wash the sheets for 9 months on that bed? That's preposterous, and yet this is a reason why this evidence shouldn't come in. Somehow we're to be penalized because victims don't want to show up. They don't want to go through what Gavin Arvizo went through. It takes a lot of courage to do what that young lad did. And I don't think, as Urquiza said in his testimony, most children don't ever, in their entire life, disclose. And it's not a far stretch to believe that the reason they don't disclose is for the very reasons that we've seen in this courtroom. That no family and no child wants to go through what you have to go through to be vindicated when you're molested by an adult, by somebody you trust and somebody you loved at one point in time, as somebody you cared for. They put it behind themselves and they move on with their lives. Their lives aren't always the same, but that's what they do. With regard to Mr. Jones, counsel is correct. Mr. Jones has now recanted what he said. However, Mr. Jones is in the unenviable position of the fact that we have two witnesses to whom he made the statement, and more importantly than that, we have his own writings where he describes the incident in detail. So it's true, I don't know what he's going to say when he takes the witness stand, but the fact of the matter is, he's pinned down pretty strongly to what he saw, who the circumstances were, and who the children and the family involved were. I guess I want to just end by saying one other thing. I'm just not going to get involved in debating the issue of where we are in this case. I think as far as we're concerned, we're very pleased with where we are in this case, and pleased with the way the victims have held up and the families held up. And I know Mr. Mesereau has made a lot of allegations about what's going to come with Janet Arvizo when she takes the stand, but I hope he does a better job than he has with the assertions he made in his opening statement with regard to certain witnesses who claim she's running around with her hand out all the time. Because not one single witness in this case has said that yet. But the fact of the matter is, if you notice, Mr. Mesereau talked a lot about facts. But we're lawyers. And the fact of the matter is, when a court in your position is asked to make decisions of law, decisions of admissibility, decisions on the application of laws of the state of California as enacted by the legislature, the fact of the matter is, that the primary thing for this court to look at is what other courts have done, and even more important than that, what have the higher courts in this state done in cases of a similar or like nature? And the reason that I think that the defense position not only in their written briefs to this court, but in Mr. Mesereau's recitation to you is empty, totally empty of any evaluation or analysis of the cases that we have cited to you, probably 50 cases, in our brief, is the fact that none of them support them, as a legal matter. None of them. And I have not heard one word in this an attempt to distinguish as a legal matter any of those cases that we cited to this court. Why aren't any of those cases on remoteness applicable here? Why aren't the issues on undue consumption? Why is the law on inflammatory, on prejudicial? Why the cases we cited don't apply here? And I say to the court that in the decision-making position that you're in, this is more than simply a factual analysis. It's the applying of the facts that the court knows them to the legal principles that have been enunciated by the state and the judiciary of the state of California. That's the position that this court is in. And unfortunately for the defense, they're in the position that they can't find a single case that supports their position, and that is the bottom line on everything that's gone on here this morning.
The arguments presented by both sides here were very good arguments, and their arguments bringing up the law and the factors that I've been working with trying to reach a decision in this matter, which is of such great importance in this case for both sides. The arguments didn't really bring up new material, but they definitely emphasized the concerns that I've had. You know, the weighing of the case as I've heard it, the remoteness of the alleged charges that would come under 1108. But ultimately the decision I've reached, and which I'll now announce, is that I am going to permit the testimony with regard to the sexual offenses, and the alleged pattern of grooming activities, which is 1101 material, leading up to the sexual offenses against Jason Francia, Wade Robeson, Macaulay Culkin, Jordan Chandler, and Brett Barnes. The witnesses that would be permitted to testify under this order would be Jason Francia, Blanca Francia, Charlie Michaels, Philip Lamarck, Adrian McManus, Ralph Chacon, June Chandler, Bob Jones, and Charmaine Sternberg. The evidence of alleged grooming of the other children will not be permitted. Evidence as to Jimmy Safechuck and Jonathan Spence will not be permitted. The witnesses that would be precluded under this ruling would be Jolie Levine and Mary Collar. And there was only one part of Bob Jones' testimony that I would consider admissible, that relating to the one physical act that he observed. And some of the testimony of Blanca Francia and June Chandler and Charmaine Sternberg would not be admissible. But I think if you can see the way I've divided that up, the grooming testimony is limited to those cases where there's actual physical sexual conduct that's been observed by somebody. That really is where I've drawn the line. And just to give you an example, Mr. Jones' observations over a long period of time were conclusionary and opinions that I wouldn't allow based on what he didn't see. All right, now, the next item I want to take up is the settlement issues of whether or not the settlements are admissible. In the one case, the Chandler case, I'm going to rule that the evidence that there was a settlement may come in, the amount may not. The second issue on the other child, I'm not sure. Mr. Sneddon, in your papers, you related to that. In your points and authorities, you related to a claim that was settled. Was there a lawsuit or not a lawsuit in that case?
There was not a lawsuit. It was settled prior to the commencement of, it was settled in lieu of filing of a civil complaint.
It was settled under threat of lawsuit type of settlement.
That's my understanding from talking to the lawyer. Yes, sir. Lawyers.
Well, again, the amount won't be admissible except I say that it's not admissible by the prosecution to prove anything. The defense, if they want to raise the amount to prove something, it's not the same side. It's not two different sides of the same coin. It's in the court's opinion. The amount doesn't prove anything. The settlement leaves inferences. For the defense, though, the amount may prove something if they choose to use it. So I'm making a ruling that applies one way to this side and the other way to this side. That doesn't mean you have to. It just means I'm not taking that away from you. I'm taking it away from them. Now, having said what my intended ruling is, if anyone wants to address that, you may.
I think we're going to submit at this point, Your Honor.
All right, thank you.
We may.
They can't hear you. They're all waving. Either they can't hear or they just want you to wave to them.
Indicating. I think we'll submit at this point, Your Honor. We may ask for leave to revisit the issue in the future.
Yes, you may. It probably won't come up for a while. But sort of a secondary issue here today. And, okay, I don't think there's any other issue pending. If we have nothing else, then we'll recess until 11:30 when the jurors will be here. We'll start as soon after 11:30 as we can, because we'll have already had our break.